Morning everyone, I hope you can hear me at the back. So during the talk I will be helping you to understand what the gig economy is. I'll be covering some recent cases where the courts and the tribunals have considered whether gig economy workers are genuinely self-employed or actually workers. And then I'll be giving some tips for businesses who engage casual workers and who engage potential gig economy workers so that you know what you should be covering in your contractual arrangements. So what is the gig economy? Well, people that work in the gig economy essentially move from gig to gig. So if you imagine a rock band, they'll move from one gig to the next, and a gig economy worker will move from picking up one passenger as a taxi driver to the next, or giving one massage to the next massage, or fixing someone's plumbing and then going to the next house. They're usually employed under an umbrella contract rather than a succession of individual contracts, and they're employed by a particular company, so it could be Uber, Deliveroo, City Sprint, and the people that are the gig economy workers choose whether or not to accept a particular assignment when it's offered. So in some ways the arrangement is quite similar to the casual worker or 0 hours worker arrangements. As Mark mentioned, there's been a lot of press about the gig economy recently. Mark's reeled off the cases and I'll be looking at those shortly. But the media has been largely negative, as you've probably seen. The perception seems to be that the employers in the gig economy, and I use the term employer very loosely here, the businesses that engage gig economy workers, are taking advantage of the vulnerable. They're often immigrant workers with very little English. English might be their second language. There's been a lot of stories about how they're paid less than the national minimum wage, they don't get a holiday, they don't get sick pay, and they're not protected from unfair dismissal or redundancy. So I know that claimant lawyers that advise individuals in the gig economy view them as essentially modern day dockers. So they turn up for work every day not knowing whether there'll be a job for them to do. However, people that work in the gig economy, by and large, really enjoy it. They enjoy the flexibility and the freedom. So, for example, if you're a student, at the weekend, you might do some work for Deliveroo or after school, after your studies. If you're a carer or a parent, once your children are at school, you've then got the opportunity to go from being mum's taxi in the evening to being a paid taxi driver during the day. So there's a real benefit to the consumer, there's a benefit to the people working in the gig economy, and there's a benefit to the end user. It's important to determine worker status for two reasons, for tax law and for employment law. So for tax law, you're either self-employed or you're employed. There's no middle ground. Whereas in the employment law sphere, we've got this concept of self-employed, genuinely self-employed, worker, and then employee. And employment rights cascade down. So at the very top, you've got employment rights. And so employees benefit, as you know, from unfair dismissal protection, redundancy pay, national minimum wage, holiday sick pay, etc. Workers are then slightly lower down, so they still have the benefit of discrimination law. They're entitled to national minimum wage, protection from unlawful deductions, but they don't receive other benefits like unfair dismissal or redundancy payments. And then finally, you've got the genuinely self-employed who aren't entitled to the national minimum wage or paid holiday or sick pay. All they really have is the benefit of discrimination protection. The legal definition of a worker, because that's the thing that's usually in dispute, is set out in the Employment Rights Act. And you're a worker if you're an individual engaged under a contract, and that contract can be express or implied, it can be oral, it can be in writing. And the personal service element of the test is particularly important. That is where a lot of the case law tends to focus. It's also important that the relationship between the company engaging the worker and the worker themselves isn't one of customer-client relationship. So, for example, if you have a cleaner that comes in periodically or a gardener, then it's unlikely that they would be your worker. They're much more likely to be self-employed because you are their customer. The tribunal tends to pay particular close attention to the three final bullet points. It will look at whether an individual has the right to bring in a substitute to do the work for them. So, for example, if your gardener said, "I'm not well, but this other guy who I know can come and do it," you're unlikely to object. Whereas if you're, as we'll see shortly, an Uber driver, Uber drivers can't just ask a friend to drive their taxi for them because they have to be CRB checked and that sort of thing. The tribunal also looks at the relationship between the two parties in terms of how much control there is, whether the individual is essentially subordinate to the company, and to what extent they're integrated into the business. Do they wear uniforms? How are they held out on the website? And then they'll also consider whether the individual works under a succession of individual discrete contracts, or whether there's a kind of overarching umbrella contract whereby the individual can accept work from time to time. So starting with the Uber case, I mean, really, I think Uber epitomises the gig economy. The Uber case was the first in a series of claims which were brought by either individual gig economy workers or groups of workers arguing for, in most cases, worker status, either for minimum wage purposes or for holiday pay. If you're interested in the gig economy, I do recommend reading the Uber judgment. It's 30 pages long, which is pretty big for an employment tribunal judgment. But it quotes US case law, it quotes Hamlet. It's quite an unusual decision. It is very, very fact specific, as are all of these cases, but you can take some themes from them. So Uber was sued by a group of drivers who claimed that they weren't receiving the national minimum wage or getting paid time off, and that they should have had those because they're workers rather than self-employed. And Uber argued that it wasn't a taxi service. Instead, it provides an online platform which connects drivers with passengers. So Uber argued that its drivers, and it could demonstrate this through the contractual documentation, that the drivers were under no obligation to accept work. They weren't even obliged to turn on the app on a particular day. They could accept rides, they could decline rides. If they declined more than 3 rides in a row, then they were switched out of the app for a short while. But Uber say that's because they need to maintain a kind of critical mass of drivers in order to provide a responsive service, and a more responsive service than, say, black taxis or a rival firm. There's an invoice which on the app is purportedly sent between the driver and the passenger, but the driver never actually knows the passenger's name or identity. They don't know when the individual's getting in the cab where they're going, and the driver has no control over, or no real control over the price. Although he or she can lower the price, they can't raise it. The Uber app determines the price and recommends the route. Uber does, however, take the financial risk. So you probably read about the odd incident where someone's travelling from, say, Brixton to Croydon via Bristol, and their 15 quid journey turns into a 500 quid journey. Well, Uber accepts that risk. That doesn't fall onto the driver. When the judge considered the matter, he looked at the contract quite carefully between Uber and the drivers, and he really didn't like it. He described it as using twisted language, as being a work of fiction. I think that we'd probably be quite proud of this, but he said there was an army of lawyers who drafted this document, and it misrepresented both parties' rights and obligations in order to protect Uber. Now, I have to be clear, we didn't draft that contract. But so what the judge actually did was he looked behind the contract, and he really wanted to understand how it worked in practice. And what he decided was that the Uber drivers were workers for national minimum wage purposes. Now, that is just these handful of drivers that were suing. That's not every single Uber driver out there. And he felt that when the drivers had the app switched on, when they were within the particular territory in which they worked, and when they were willing and able to accept work, then they were workers. He didn't find that there was any real relationship between the driver and the passenger, and he completely refused to accept the argument that essentially there are 30,000 small businesses driving around London on any given day. He was also particularly swayed by the fact that Uber drivers can't bring in someone else to drive a taxi for them because of the regulatory requirements that, they have to be CRB checked, as I mentioned. And Uber is appealing the decision. So hopefully we will know more in due course as to where that case is going. So Uber was at the end of last year, and then earlier this year we had the Dewhurst and City Sprint case. For those that don't know, City Sprint is a big courier company. I think it's one of the largest in the UK. It's got over 3,000 couriers, 50 of which are cycle couriers in London. And Dewhurst was one of those cycle couriers. And the tribunal, she sued because she said that she only wanted like 2 days holiday, and this ended up in a case with QCs on both sides. But she argued that she was a worker and that she was entitled to 2 days pay. Despite the contractual arrangement being very clear that she was a self-employed contractor, she'd acknowledged that, she'd signed off on that. But again, the tribunal looked behind the contractual documentation. And what it found was that to be a courier for City Sprint, you need to spend 2 days in a recruitment process. And then after that recruitment process, you're given this wonderfully titled document called a confirmation of tender to supply courier services. So not a service contract or an engagement letter. And under that contract, the couriers were self-employed contractors. There was no obligation on them to accept work, but what the tribunal found in practice was that to remain on this kind of small list of preferred couriers, you had to agree to work, say, 3, 4 or 5 days a week and nominate what those days were in advance. And then once you'd agreed those days, your hours would be essentially agreed with City Sprint. So the courier would say, right, I'm now in London, I'm logged on, and then they would go around delivering packages all day. And then towards the end of the day, sort of 6 o'clock at night, they would say, is it convenient for me to go? And if the controller said, no, we've got some more packages to deliver, they would be expected, or the couriers certainly felt that they were expected to keep on delivering. Also, although there was a stated right that they could subcontract their work to a substitute, the judge found that in practice that never actually happened. When people asked for it, it was rejected generally by cycle couriers, or if they could subcontract, it would only be to another City Sprint approved courier. So the tribunal also looked at the way that it worked in practice, and the fact that City Sprint tells its couriers to always smile when you deliver your packages because that sets the right tone. It gave them express instructions as to what to do if someone wasn't in when they were delivering the package, and most City Sprint couriers wore branded gear. So again, the tribunal found that the tender document didn't reflect the true relationship. It looked behind the contract, it looked at reality, and it found that the courier in this case was a worker when she was logged on. So finally, we've got the Smith and Pimlico Plumbers case. For those of you that don't know, I mean, this was only reported last month, but Mr. Smith had been working for Pimlico Plumbers for over 5 years. He suffered a heart attack, and a few months later, Pimlico Plumbers terminated their arrangement with him. So he sued in the Employment Tribunal for unfair dismissal, so he was arguing he was an employee, and he sued for holiday pay, unlawful deductions, and various other things. So the tribunal had to look at whether he was genuinely self-employed, which is what Pimlico Plumbers argued, whether he was a worker like the Uber and City Sprint guys, or whether he was an employee. And Pimlico Plumbers said that he was an independent contractor, and they pointed to the documentation, which again looks pretty clear on the face of it. There was no obligation on Smith to accept any work, but there was an expectation that he worked a minimum of 40 hours per week for Pimlico Plumbers. Mr. Smith had to provide his own materials, his own tools, etc., which again is the sort of thing that you would point towards self-employed status. But then at the same time, he drove around in a van provided by Pimlico Plumbers. He also wore their uniform. If anything happened, went wrong, the financial risk was with Smith. He was VAT registered. He filled out self-employed tax returns each year. And he admitted to the tribunal that during his 5 years with Pimlico Plumbers, he felt he was self-employed. But then he got fired and he decided actually he was an employee. The Court of Appeal decided that Smith was a worker. He wasn't an employee, but he was a worker. And they were particularly swayed by the express contractual provision that he wasn't able to subcontract his services or to provide a replacement, even though they found that in practice, from time to time, plumbers did switch jobs between them. And the court felt that that clear right that there was no right of substitution pointed to the fact that that he was a worker. So what can we expect next in the world of the gig economy? Well, we know from talking to claimant lawyers that act for individuals or groups of individuals in the gig economy that what they want to push for is an increase in the level of rights afforded to those people while they're actually engaged in work. So at the moment, you'll have seen that they've all been deemed to be workers, but the claimants are hoping that they can persuade the tribunal that actually they're employees. And one of the benefits for them in doing that is, as you'll all know, if you're an employee, you're entitled to a Section 1 Statement of Terms and Conditions of Employment. And if you don't receive that, then you can bring a claim in the tribunal. It has to be attached to another claim, but you can bring a claim for between about £1,000 and £2,000 per individual. So if you're one of these claimant law firms and you can get even 10% of the 30,000 Uber drivers to come and bring a claim for you, that's a multi-million pound claim. So you can see where there's a real incentive to these people to bring these types of claim. The government is also concerned about whether the current law is sufficient for the what's going on at the moment, and so Theresa May actually, it's one of the first things she asked the government to do was to look into modern working practices, and the initial statements have come from that. The review appear to be fairly in favour of the gig economy. They recognise that they want to maintain flexibility while supporting job security. But a lot of employment lawyers are speculating about whether worker status will go. In other European countries like Ireland, for example, you're only an employee or you're self-employed. It would also mean that our employment law better mirrored our tax law. And so you could see that's a potential outcome. Alternatively, you could see more categories of worker created. The Office of Tax Simplification is also looking at this matter. As I mentioned earlier, you've got 30,000 Uber drivers. It's unlikely that any of them are making enough money each year to satisfy the VAT threshold. They're also not paying, they're not going through PAYE, so it's more difficult for the government to recover national insurance contributions and income tax. And so there's a real advantage to the government in trying to make sure it properly collects tax from these people. So if you are thinking of engaging gig economy workers, I'm afraid there's no magic wand as to how best to draft the contractual documentation. Having gone through the cases, the contracts seem to be very clear as to how the arrangement should work in practice, and that the individuals wouldn't be workers, they would be self-employed, but we've seen in practice that just wasn't the case. So it's critical that you do make sure that any contractual arrangements reflect reality. Don't, for example, say you've got no control over the way the individual performs their services if you are going to then discipline them or take them off a roster if they don't do it in the way that you want them to do. You need to balance your kind of commercial objectives with the employment law risk, because if you've got people out representing your business, there's a good chance you will want them to wear your uniform, to work in a particular way. You probably want to describe them as our staff. But in the City Sprint case, the tribunal was exceptionally critical of the fact that City Sprint argued that its couriers were our couriers on its website, but then said they were all self-employed in reality. If you can, think about who's paying the individual. Can the end user pay the individual rather than the company controlling them? Is there any way they could invoice them rather than it going through you? And the right of substitution is important. We are often asked to draft consultancy agreements where we include a right of substitution, but in practice everyone knows that they've got this particular individual as a consultant because they want his or her particular skill set, and so having it in there, we've now seen the courts will just look straight behind it. If you do think there's a risk that an individual will be a worker, then I think you should address that head on. Think about at what point they might gain worker protection. Is it all the time, or is it only while they're doing particular tasks? If they are, can you make sure that they receive national minimum wage or holiday pay in those periods? And also think about whether there are ways of breaking service so you can deny the individual continuity for the purposes of claiming back pay, etc. So hopefully that's been a helpful whistle-stop tour of the gig economy. And with that, I'll hand over to Daisy.